I'm Jim Zirin, and you are watching Conversations in the Digital Age. Among lawyers, there is no one in the last half century more distinguished, better known, or more highly respected than our guest, Robert B. Fiske, Jr. Bob Fiske has written a memoir. The memoir records the important events in his life as a prosecutor, as a defense lawyer, and as a counselor. So, of course, the title of the book is Prosecutor, Defense Lawyer, and Counselor. And Bob, we're delighted to have you with us.
Thanks, Jim.
And congratulations on your book. And of course, the first question is always, you had such a wonderful career as a lawyer. Whatever possessed you to write a book?
Well, it started out very modestly. Members of my family and a few friends said I should write a book. And originally it was just intended for a very limited audience. And then once I got into it, other people started saying, well, you should write this for a broader audience. So as I went along, I decided I would, because I thought that maybe my book could be a good example for young lawyers coming along.
Well, of course, you were the United States Attorney for the Southern District. You distinguished lawyer in private practice at Davis Polk, and you were the Whitewater special prosecutor. A lawyer couldn't ask for a more varied and more challenging career. But let's start at the beginning. You graduate from Michigan Law School, and you're an associate at Davis Polk. I think you say you signed on at the princely salary of $4,200 a year. And then what happens to you?
Well, I was at Davis Polk for 2 years, and then I had been a student assistant in the U.S. Attorney's Office in my junior year in law school when Judge Lombard started the program. And so I sort of got the bug that summer, and I knew I wanted to go back after I got some experience at Davis Polk. So after a couple of years, I went back to the U.S. Attorney's Office as an assistant and served. Judge Lombard had gone on to the Court of Appeals, so I served under Paul Williams and later under a Davis Polk partner, Hazard Gillespie.
Well, let's just back up a minute. You want to leave Davis Polk, and you think it's great experience in the U.S. Attorney's Office, so you begin a dialogue with the litigation partners there. And are they happy to see you go? Do they want you to go to the U.S. Attorney's Office?
Well, you know, you have to understand that back then in 1957, the U.S. Attorney, going to the U.S. Attorney's Office was a brand new phenomenon. For 20 years under the Democrats, and this isn't necessarily a political statement, but the office had degenerated to the point where people were picked basically for political considerations. It was a part-time job. Judge Lombard came in and changed all that, made it the way it is today. People have followed in his mold since. But it was a brand new thing for people to go to the U.S. Attorney's Office. Not for virtually no firms at that point were sending people there. So after I'd had the summer there, knew I wanted to go back, I went to Hazard Gillespie, who I was working for, and said I wanted to go back, and he just pretty mildly reacted negatively. He said, you know, that's a huge mistake. You're here with 3 or 4 other people that you're competing with. You'll go way up there for 3 years. I'm not sure we'd take you back, but if we did, you'd be way behind because the other people you'd be competing with would be working with the partners. So it's a terrible mistake. And
they even sent you to someone else for a special opinion, didn't they?
Well, I went back to Judge Lombard and told him this, and he said, well, you know, have any of them done it? I thought that was a pretty good question. So I went back to Gillespie and said, I really want to do it. And he said, I'll tell you what, you ought to go see a very distinguished member of the New York Bar, Bruce Bromley, that
been a judge,
managing partner of Cravath, had been a judge, had been in public service. He'll give you independent advice. Well, I never knew whether there was a back channel conversation between them or not, but when I went in, Judge Bromley said exactly the same thing Gillespie had said. Don't do it. You're having a great experience with people like Ralph Carson, Hazard Gillespie. You throw that all away. So
you threw it all away.
I did.
And you go into the U.S. Attorney's Office, and you start under Paul Williams. You start trying your own cases, and you're having a great old time, and William steps down, and who's the new U.S. attorney?
Hazard Gillespie.
Hazard Gillespie, the guy who advised against it. So he didn't take his own advice.
Great moment riding in on the train when it was a total surprise. We all thought Arthur Christie, who'd been the acting U.S. attorney, would probably get it. And I'm coming in on the train one day, and there it is on the front page. But I got to the office, and literally the phone was ringing as I walked in the door. And it was Gillespie, and he said, I guess you read the paper. He said, you were right, I was wrong. When can I come up and talk to you about what this is all about? So we had a great relationship, and for many years, and he was one of my important mentors and role models.
He was a great lawyer.
He was.
Now, Paul Curran, who was an assistant United States attorney and a United States attorney, said that the second greatest public service job in the United States is to be the United States attorney for the Southern District of New York. The greatest is to be an assistant United States attorney. So do you agree with him? And tell about your experience as an assistant.
Well, I think what Paul was saying, and I think everybody that's been an assistant, and there have been hundreds of them, feel the same way, no matter what U.S. attorney you served under. There's something about that experience, the collegiality, the teamwork, the working together, the experience you get in court representing the government. But there's a bonding, and the friendships you make in that position are friends you make for life. And I think it's those sort of intangibles that make that job what it is, as well as the great experience you get, responsibility you get, you'd never get in private practice. Trying somebody like Johnny Dio, who blinded Victor Rizal. I tried him when I was 28 years old. Where would you get that kind of experience in private practice?
Well, let's see. At this point, Gillespie had promoted you to head of the organized crime division,
yes.
and also assistant chief of the criminal division.
I started as assistant chief, and then I moved over to organized crime, and Kevin Duffy took my place as assistant chief of the criminal division.
Later to become a judge.
Correct.
But let's talk about Johnny Dio. I mean, he was a vile sort of character, and Victor Rizal was a columnist specializing in labor matters, and he was stepping on Dio's toes, and he found himself with a bottle of acid in his eyes. He was blinded.
Well, the U.S. Attorney's Office was doing a grand jury investigation into labor racketeering. Victor Rizal was writing columns for the Daily Mirror about labor racketeering and revealing a lot of very helpful information to the investigation. And there was a working relationship there where Rizal was helping them. And one day he stepped out of a restaurant and somebody threw acid in his face and blinded him. And it was traced to Johnny Dio.
And you tried that case, or what happened with that case?
Well, I tried it. I tried it against one of the best defense lawyers at the time, a man named Colonel Kleinman, in front of
Bill Kleinman,
one of the best judges of all time, Edward Weinfeld.
And what happened?
Well, we convicted him.
That's good.
Went to jail.
He went to jail. So that was certainly a feather in your cap. Now, in the U.S. Attorney's Office, at that time, under first Curran, then Gillespie, there were other lawyers there who later achieved eminence either on the bench or at the bar. Can you name some of those?
Well, the ones I started with in the summer program included Herb Wachtell, who went on with Marty Lipton to build the Wachtell-Lipton law firm. Jerry Gattell was a federal judge. Freddie Pierotta went on to become an insurance commissioner, and it was an all-star lineup.
Yeah. But after 3 years or 4 years in the office, you decide to go back to Davis Polk.
There was a change in administration. Bob Morgenthau came in as U.S. Attorney. Gillespie left to go back to Davis Polk, and I went back with him.
And now what happens to you at Davis Polk? This was all becoming a very fascinating story. I can see why the book is doing so well.
Well, I went back, and I was welcomed back by everyone, and I thought I had a little bit of a leg up. I'd worked for Gillespie, and Judge Walsh had come down from being Deputy Attorney General. He came back to Davis Polk. So I thought with them I was in pretty good standing. But there were a couple of other partners that I think were anxious to show me that because I'd been up there making headlines while my contemporaries had been working for them, I really didn't have a leg up, and I was nothing special. I was going to be treated just like the run-of-the-mill associate, and I was by them.
But such a run-of-the-mill associate, you became a partner.
Yes, I did.
And this is out of Gilbert and Sullivan. And then you become a partner at Davis Polk, and you're handling a number of interesting matters. Brilliant career at the private bar ahead of you, and then opportunity knocks again in the public sector in 1976. Tell about that.
Well, in the aftermath of Watergate, in order to restore credibility to the Justice Department, President Ford asked Edward Levy, the president of Chicago University, to come in as Attorney General, which was a brilliant stroke. And Levy, who had no experience in law enforcement, recognized he needed a solid person as Deputy Attorney General. So he asked Harold Tyler, a distinguished New York lawyer who was a federal judge, to step down from the bench and come down to become Deputy Attorney General, the same way Judge Walsh had done in the Eisenhower administration. And I tried some cases in front of Tyler, and I knew him, so he was a friend. And when the U.S. Attorney's position opened up, he asked me if I'd be interested, and I said I certainly was. So it was the best job in the country.
So when the call came, you didn't talk to Hazard Gillespie and ask him whether he thought you should do it?
No, no. That took about 1 second to say
It took about 1 second
yes.
to say yes. The offer comes, you say yes. I remember when I was offered an appointment as an assistant United States attorney, I just said yes. It was.
Well, for me, Paul Curran may think it's the second best job. I thought it was the best job in the country for me.
Well, you had, am I correct? Most U.S. attorneys for the Southern District of New York and elsewhere haven't tried their own cases. But when you went there, did you have a resolve that you would at least try some of the important cases in the office?
Yes, and every U.S. attorney is different, obviously, but I was a great admirer of Judge Lombard, and he tried cases when he was U.S. attorney, and he felt that going out there, leading the trial team, was an important part of leadership for the office, sort of like the general going into battle ahead of his troops. And I felt the same way, and I wanted to find the right case, and then one came along pretty quickly that I was really, in effect, asked to try by the Attorney General.
So tell about that case.
Well, there was a drug dealer named Nicky Barnes, who was the biggest drug dealer in New York, probably in the country. He'd been acquitted 4 times in prosecutions by the state, developed a reputation for being Mr. Untouchable. And after we indicted him in the spring of 1977, the New York Times in June had a front page article on their magazine section, a picture of him on the cover, a very arrogant pose, saying this is Mr. Untouchable. And there was an article that basically said, this guy's a role model for young kids in Harlem and the South Bronx because he makes hundreds of $millions for his drug ring, selling drugs, and he's untouchable. And the little kids in Harlem thought this is a viable career path. And he had a
cool guy,
flaunting law enforcement. So anyway, I come into the office Monday morning, the phone rings, it's Attorney General Griffin Bell. He said, Bob,
So this is in the Carter administration.
He said, I've just come from a cabinet meeting. President Carter read this article. And he said to me, this is the most important case in the country, because if we can't put somebody like this away, there's something wrong with our criminal justice system. And Bell said, Carter had said to him, we have a good case, don't we? And Bell, of course, knew nothing. And he said, oh, yes, Mr. President, don't worry, we've got a very strong case. And then he said to me, we do, don't we, Bob? And I said, well, you know, we got informants, we got our problems, but I think we'll be okay. And then there was kind of a pause, and then he said, Judge Bell said, well, I hope we're sending in the first team. So I took over that case and tried it. And then I tried later another major case against Anthony Scotto, the head of the ILA in New York.
That was for labor racketeering.
Labor racketeering, yes. And that's one I felt I should try also because it was very important to the FBI. They had a whole crusade up the whole East Coast on cracking down on the ILA, and it was a coordinated effort between all the cities on the East Coast. This was sort of the linchpin of the whole thing, and I felt I should go out in front on that one too.
So you tried these cases while you're administering a large, in effect, a large law firm. How many lawyers were there in the U.S. Attorney's office?
Back then there were about 100.
100, and you were there for 4 years.
Yes.
And who were some of the luminaries whom you appointed as Assistant United States Attorney?
Well, one of the reasons that I was able to try these 2 cases, and each one took about 10 weeks, was because I had such a superb executive staff. And you know, you've been in the office, but one of the great things about that office is that it's seamless in two important respects. Every new U.S. attorney that comes in inherits an all-star team of assistants appointed without political considerations by his or her predecessor. So all they have to do is bring in their own executive staff. And when they do that, it's very common to reach back into prior administrations, again, regardless of politics. So I had people like Elkin Abramowitz, John Doyle, Dan Murdoch, all of whom had served under Bob Morgenthau, as well as Bill Tendy, who had been an assistant with me back
Served
in
under
the Paul
everybody.
Williams day, and had served with enormous distinction ever since. And one of the best things I ever did for the office, I think, was bring Bill back to come in as executive assistant to sort of stabilize the office.
Consigliere.
Yeah, he was incredible. But those are the kind of people that we had.
And so you, 4 years in the U.S. Attorney's Office, and then time comes to leave. What do you do?
Back to Davis.
Back to
Polk.
Davis Polk.
Yeah, I never wanted to.
Is there
go
any
there.
other law firm in the city?
Well, there were other firms, but I always liked Davis Polk because of the collegiality and the people and the values at that firm. And it was never any question in my mind. Each time I left public service, I never wavered for a second. I always knew I wanted to go back to Davis Polk, which I did, and very happy that I did.
You're a sailor. You steer a clear course.
That's right.
All right, so we're back at Davis Polk now. Tell us about some of the really challenging cases you had there.
Well, I left Davis Polk on March 1, 1980, and I took about 3 weeks off, and I came back on March 21st. And riding in on the train, another big train ride, I noticed an article in the front page of the business section that the the owner of the utility at 3 Mile Island had just filed a $4 billion lawsuit against the manufacturer of the reactor arising out of the accident that had occurred a year before, claiming that it was the manufacturer's fault that the accident had occurred. And I had thought sort of myself that I'd get back to Davis Polk, I'd walk the halls, I'd say hello, I'd sort of ease into it gradually. The next morning the phone rang, and it was somebody from Babcock and Wilcox asking whether I would take on that case. So I did. So within a day, I got plunged into one of the more high-profile cases of the 80s.
And how did that case end?
Well, we defended it very successfully. The case went on for 3 months, and then basically the other side dropped the case in return for some commercial transaction that was actually very beneficial to our client. So we considered that a win.
I referred to your career as a sailor. You have been a seasoned sailor, but you had a case involving sailing, didn't you?
Yes, I did.
Well, tell about that.
Well, this was the America's Cup, involved the America's Cup.
And who was your adversary in that case?
Well, Harold Tyler.
Harold Tyler. So your old friend Harold Tyler winds up being your adversary.
He did.
Is that what lawyers do? They have friends as adversaries?
All the time. And it's one of the great things about the legal profession. That if you do it right, if you conduct yourself right, you can have as good friends with your adversaries as you do with your colleagues.
And is your relationship the same when you're adverse as it is when you're just pals and having a drink at a bar?
Absolutely. I mean, assuming you litigate the case and they litigate the case the way good lawyers should, sometimes it even strengthens a relationship. I think I had a closer relationship with Ace Tyler after that case than I did before. In fact, I was asked to he received an award for the Boy Scouts, and I was asked to present the award. And the whole issue in this case was whether it violated the spirit of the deed of the gift of the America's Cup to race a catamaran against, which San Diego did, his client, against my client, New Zealand, which raced a monohull, which all sailors know was unconscionable. So when I presented the award to him at the Boy Scouts, I said, he certainly deserves this award, and I can forgive him in presenting the award for the fact that he represented somebody that raced a catamaran against a monohull. So it was that kind of good spirit that continued on in our relationship.
You write in your book that you've always gravitated towards sports, and you've been a hockey player and a cyclist, and you ran a marathon, and we talked about you being a sailor, but you also had sports cases. Didn't you have a football case as well?
Yes, we representing the National Football League against the U.S. Football League, which had gone out of business, and then trying to compete with the National Football League, and then had sued them, claiming they went out of business because the NFL had unfairly monopolized football and television. And I tried that case, actually as co-counsel with Frank Rothman of Skadden Arps. And again, we won that case by any reasonable person's definition.
Because the verdict was for the plaintiff for $1.
Correct. And actually there was a huge irony. They got collected $1 in damages. They got no injunctive relief. But then they prevailed before Judge Zirin in the Court of Appeals when they sued for attorney's fees on the theory that they were, quote, the prevailing party. And both Judge Zirin and the Second Circuit agreed that they were the prevailing party because there was a finding of monopoly, even though they only got $1.
The Clayton
no
Act,
injunctive relief.
the Clayton Antitrust Act says that the prevailing party gets his legal fees.
Right.
It's one of the
Right.
unusual situations in our jurisprudence where would go against we have the loser pays rule in effect.
Right.
If the defendant prevails, does it pay the plaintiff's legal fees? Yes, but if what's the rule?
If the plaintiff prevails, then the
He gets his
defendant
legal
has to
fees.
pay the attorney's fees. If the defendant wins, the plaintiff doesn't have to pay the defendant's fees. No.
Yeah, very interesting. Now, let's talk about the Whitewater situation. What happened there?
It's a long story, but I'll make it short. I was appointed as independent counsel in January of 1994 by Janet Reno. At that time, the independent counsel statute, which had been in effect before, which allowed a 3-judge court to appoint an independent counsel without, which would protect them from being fired without the court approving it, that had lapsed. So there was no statute in effect, but she appointed me, and I was appointed on the same way, actually, Archibald Cox had been appointed by Elliot Richardson in Watergate.
And you hadn't quite completed your work when the judges under the new statute pulled the rug out from under you.
Well, we've been doing it for 6 months, and then the independent counsel statute was renewed, and Janet Reno, as she was allowed to, apply to the 3-judge court under the statute to appoint an independent counsel, said it should be me. Court disagreed and said they wanted to pick their own person, which they did.
And that was one of the few disappointments you've had in your career. I think you relate another one where you almost became the Deputy Attorney General of the United States.
Yes, I think Dick Thornburg, who was the Attorney General, asked me to be Deputy Attorney General, and he wanted me to do that, and I wanted to do it, but I had been chairman of the ABA Judiciary Committee, and we'd run afoul of some conservatives in the Republican Party who thought that the committee had disapproved candidates because of ideological reasons rather than professional reasons. Wasn't true, but that was their perception. And then, of course, there was a divided vote in the committee on Robert Bork, and they held that against the committee, even though I myself supported Bork. So I think it was, as Thornburg said in his book, describing this whole thing, he said he thought those conservatives were out to get the ABA, and I was a convenient target. So basically, in the end, based on their opposition, President Bush said much as he'd like to, he didn't think it was worth the risk, so I withdrew.
Well, you've had an absolutely fascinating career. I know there are many other aspects of it we could go into if we had the time, but I have a question for you. I think it was Sophie Tucker who said, I've been rich and I've been poor and rich is better. You've been a prosecutor and a defense lawyer. Bob Fiske, which has been better?
Well, I told the U.S. Attorney's Office when I left in 1980, I was 50 years old, and I said at a farewell dinner, I know when I'm 80 years old, I'm going to look back on my career and I'm going to say these were the best 4 years.
The best 4 years. What a sweet...
3 years ago when I was 80, we had another dinner and I said, I'm 80 years old, and it was the best 4 years. I had a fantastic career at Davis Polk. I couldn't have had a better group of lawyers to practice with. I enjoyed every minute of it, but there's just something special about the U.S. Attorney's Office.
Something special about the U.S. Attorney's Office.
Yes.
Well, it's been absolutely marvelous. And Bob Fiske, thank you so much
Thank you,
for coming
Jim.
by.
Appreciate it.
And thank you for coming by. Tune in next week for more conversations in the digital age. For Conversations of the Digital Age, I'm Jim Zirin. Please visit our website at www.digitalage.org. All the best.